Hello everyone. In this video, we will discuss about five writs. So before we talk about five writs, right? Let me ask you to think of something very basic. In our daily life, whenever someone has power, right, there is always a risk that the power may be misused. It could be a police officer, a government official, or any authority. Power itself is not a problem. The real problem begins when there is no control over that power. That is exactly where the idea of writ comes in. Now, understand this clearly. The Constitution does not blindly trust anyone with the power. It assumes that mistake can happen and misuse can happen. So instead of waiting for injustice to grow, it creates a direct remedy. That remedy is called a writ. A writ is not advice, it is not a suggestion, and it is not a request. A writ is the court directly stepping and saying this is wrong and it must stop. What makes writ special is that they deal with real situations and not with the theory. Suppose someone is illegally detained, an officer refuses to do his duty, a wrong decision is passed, a court exceeds its limits, or a person occupied a public office without authority. In all these situations, the Constitution does not ask the citizen to suffer silently. The Constitution empowers the courts to act immediately through writs. So, when we study the five types of writs, we are not just learning legal terms, we are also understanding how the Constitution protects people from misuse of power. Each writ of these five solves a different problem, but all of them have one common goal to ensure that law is always stronger than the authority. Now, keep this idea in mind. Let's go step by step and understand each writ with simple examples. The first one is habeas corpus, protection of personal liberty. Habeas corpus is all about personal liberty. The Constitution treats freedom as so important that the moment someone's liberty is taken away, the law becomes extremely alert. This writ exists because detention cannot be casual, secret, or unexplained. If the state takes away someone's freedom, right, it must justify it immediately. Now understand this carefully. Arrest itself is not illegal. Police are allowed to arrest people. The real issue is whether the arrest follows the law or not. Habeas corpus does not ask whether the person is innocent or guilty. It asks only one thing: is this detention or arrest is legal? Let's take a realistic example. Suppose the police person has picked up a person late at night and do not give a clear reason and do not produce him before any court or any magistrate within the required time. So the arrested family does not know where he went or why is detained. In that situation, right, the family approaches the court and the court issues habeas corpus and orders the police to produce the detained person before the court. So once the person is produced in the court examines the legality of the detention. If the police cannot justify the reason behind the arrest or detention, the court orders immediate release. So, in simple words, whenever the freedom of any person is taken without following the law, habeas corpus is used to restore that freedom. Now, let's look at Mandamus, which is command to perform legal duty. Suppose it deals with a situation where power is exist, but it is not being used at all. Even though they have the power, right? Sometimes they don't use that power. Few public authorities are given power not to sit quietly but to perform duties. When they refuse to perform their duties or act or keep delaying without reason, that silence itself becomes illegal. Think of it this way: doing nothing can sometimes be as harmful as doing something wrong. The law expects public officers to act when a duty is imposed on them. Mandamum exists to ensure that this duty is not ignored. Example: suppose you apply for an income certificate. You submitted all the documents correctly, however, and there is no legal problem with your application as well. Still, the officer who is supposed to issue a income certificate, right? He is neither approved it or not rejected it. You are awaited for a 1 day, 2 days, 1 week, a month pass by, and no decision or no information is given to you. This delay has no justification, right? In such a case, the court issues mandamus and tells the officer that you are legally bound to decide this application. You cannot keep it pending. So, mandamus is the court forcing the authority to do its job. In short, when duty is ignored, right, mandamus makes action compulsory. Now, let's look at certiorari, cancellation of wrong orders. Certiorari comes into play when a wrong decision already exists or wrong decision is already taken. Courts or tribunals are meant to deliver the proper justice, but they can make mistakes sometimes. Sometimes they exceed their authorities, sometimes they misunderstand the law, and sometimes they decide matters unfairly. Here, the problem is not delay or silence. The problem is that an illegal order has already been passed. In that case, certiorari exists to remove such an order from the legal system. Let's look at one example. Suppose a tribunal decided a case affecting a person's right but does so without giving that a person proper hearing. So what in that case is, the tribunal has decided person's rights, however they didn't listen his hearing. The decision is announced and it is directly harms that person. The mistake has already happened. In that situation, the person approaches the High Court. The High Court examines the order and finds that it violates principles of natural justice. Though through certiorari, right, the High Court cancels the tribunal order. So whenever a completed decision is illegal, certiorari is used to correct the mistake after it has been occurred. Now let's look at prohibition, that is prevention of excess jurisdiction. Prohibition is closely related to certiorari, but the difference lies in timing. Certiorari acts after a wrong decision is already made. Prohibition acts before the wrong decision is made. Here, the law tries to prevent injustice instead of correcting it later. If an authority is clearly acting beyond its limits, the court does not wait for damage to occur. Now consider one example. Suppose a lower court starts hearing a case that by law it has no authority to hear. The case is still in progress. No judgment has been delivered yet, but the very act of hearing the case is illegal. Here, the lower court does not have rights to hear the case, but however, they are still hearing the case. In this situation, the High Court issues prohibition and orders the lower court to stop the proceedings immediately. So, prohibition is a preventive writ. It exists to stop misuse of power before an illegal decision is passed off. And the last one is Quo Warranto, authority to hold public office. This is deals with public offices and the authority to hold them. Public offices are position of trust. They give power over people and institutions. That is why the law strictly controls who can occupy them. The key idea here is simple. No one can hold a public office unless the law allows it. If someone occupies such a position without legal eligibility, the issue affects the public at large. Example, suppose a person is appointed as the head of the public institution, but later it is discovered that he does not possess the qualifications required by law. Even if no individual suffers immediate loss, the appointment itself is illegal. In such case, any citizen can approach the court and file a quo warranto. The court asks the person that by what authority are you holding this office? If the answer is not legally valid, the person is immediately removed from the appointment. So, quo warranto ensures that public power is held only by legally qualified persons. So, one by one, these writs deals with the real problems: illegal detention, ignored duty, wrong decisions, future misuse, and illegal appointments. Different situations, different writs, but one clear message that power must always function within the law. If this video is helpful, please subscribe, like, and share. Thank you for watching.